want to welcome to the program Sara Papantonio. Um, you've followed your father into the legal profession. Here, come a little bit closer to the mic. Really appreciate your joining me. And you are working on a case involving baby formula. I spoke to your father a little bit about Camp Lejeune, and we got the details on that. But you're also working on a case about baby formula. Tell me about that case.
Right. So what you're seeing right now is a ton of bad press about the formula industry. And there's two different cases that are out there.
We should say that most of the press that we're hearing about is their failure.
Really, their failure to take care of families, their failure to, protect infants, and their failure to manufacture these products in the right way. So the case that we're handling is dealing with premature infants who developed a disease called necrotizing enterocolitis. And the results of that is what's happening is these premature infants are being fed a cow's milk-based formula. This cow's milk-based formula is being advertised by the industry as being human milk and safe for premature infants. The reality of it is
it's being advertised as human milk?
It's being advertised as human milk. So the reality is what happens is the premature infant cannot properly digest that cow's milk enzyme. What happens when their bodies react to it is it ultimately creates decaying flesh. So the necrotizing enterocolitis means that the child's organs and intestinal tract is deteriorating. It's breaking down. It's turning into mush. It is a horrific injury that these children are facing. And the whole point of this case is they don't have to. These companies have known for years, decades even, that premature infants are not able to digest the cow's milk enzyme, yet it is still being manufactured to them. So that's what we're pursuing, a cause of action on behalf of families and infants who have suffered injuries, who have lost their lives because of this cow's milk-based formula that is being marketed by the infant formula.
All right. So let's back up and give me a sense of how did this stuff come? How was this sort of discovered? First off, how was it discovered, that there was this disease, which I cannot pronounce, that was taking place in premature babies? And then how was it established that, how did it come to be clear that there's a false advertising? I want to talk about maybe there's dual claims here that can operate, but just walk us through that.
So there's a lot to break down here, and I think it's helpful if we kind of start from the inception of formula. We have decades worth of history that shows that these companies have misled the American public. They've misled international families about the safety of formula products. So if you think back to, I think it was in the 70s, you had Nestle go into Africa. And what they did is they got these mothers hooked on breast milk formula. Because what we are seeing is that the whole advertising scheme here is brand loyalty. That is the goal of these formula companies. They want to almost create addiction and addicts of their formula. So you had Nestle go into Africa, get all of these women addicted and their children addicted on the formula, so their breast milk dries up. But when Nestle comes out, those women can no longer afford formula. Their breast milk is dried up, and so you have infant deaths across Africa because they don't have the nutritional support they need, because Nestle has gotten them hooked, the breast milk is dried up, and they no longer can support their child. So that was kind of the first realization that these formula companies are not as baby friendly as we'd like to think. So then you evolve into the 90s and early 2000s, and what we're seeing is study after study after study that says cow's milk is not the proper form of nutrition for a premature infant alone. Why? Because of the reaction in the child's gut. They know that. The studies have been out there for years, yet they continue to perpetuate this narrative that these babies have to grow. They have to have the formula. They can't live without it. It's an absolute false and misleading advertising. It truly is. So when we talk about formula, when you see the advertisements, when you see them flashing happy babies and loving families and mothers who are just so relieved that they're giving these families, their babies, formula, it is an absolute misleading truth. These advertising schemes that the infant formula companies are doing, I would equate them to big tobacco. I would equate them to the opioid marketing scheme. It is criminal. It's absolutely criminal.
And so how do you find these cases? Like, I mean, how did this, how does it go from that's going out there? Like, did you have clients that came in?
So the inception of this case started just as really any other case would. You spot a wrongdoing. You have a mother that comes to us and says, my child died of this necrotizing enterocolitis. I don't think it should have happened. I don't know why it happened, but I know something went wrong here. And then you have attorneys that start to look into it. They start to uncover the science. They start to see how obvious it is and how obvious it should be to these companies that their product is not safe for this infant population. And that creates a snowball effect. And that's what created this litigation. You start with one client. Word of mouth, you get 2 clients, 3 clients, and now we have thousands of people, thousands of mothers and children who have suffered at the hands of the formula companies. And we've created this shockwave across the country that is really bringing to light just how bad these formula companies are. Coupled with now you see the Similac recall cases where Abbott formula is essentially has terrible bacteria in all their facilities that is getting into the formula and then infecting the children. So we really have a lot of momentum against the formula companies right now for this litigation.
I see. And does the bacteria, which is obviously unrelated to this thing, but it shows this is a company that not necessarily putting the safety of babies before profits.
It shows that it's a company that is not operating with due diligence. They're not focused on the safety of the children. They're not focused on the good manufacturing practice. They're focused on getting these people addicted to formula and riding on that brand loyalty. What
do you need to prove? If you go to court, well, let me start with this. It's a multidistrict litigation. Why is it? What's the difference between that and a class action suit?
So it's very important to make that distinction. What we call multi-district litigations, we call mass tort cases. And what that means is that we represent the individual on every single case. We work up the individual's cases. We try their cases based on what happens specifically to them. Class action is very different because class action is where we pursue what is called an economic loss. That means all you're able to recover is that which you have spent money on. So for instance, if mothers went out and purchased the infant formula that ultimately injured their children, they would only be able to recover the money spent purchasing that product. Now, what we are able to do in our mass torts MDL world is we are able to represent that mother. We are able to show a jury the injuries these children have suffered. And we're able to recover both economic damages, those financial losses, as well as what we call non-economic damages. That's the pain and suffering this family has been through. It's the injuries that we can't see or touch, but that we feel. It's what effect that's going to have on this child's life who now has half of his intestinal tract taken out because of the necrotizing enterocolitis. So there's real value in these mass torts because we're able to tell the story in a better way than a class action.
And is it also that there's a distinction between everyone suffering the same damage, essentially, in a class action when everybody suffers the same damage? They all spent $50 on the formula, whereas in an MDL, the disease may be worse for this child than that child, and so there's a different damage that's associated with it. It's not just a set number that we can apply. That's also a distinction?
That's exactly right. Class actions are essentially a faceless mass of individuals who all suffered the exact harm. There's no variation. Here, you can have a child who passed away as a result of having this cow's milk formula, or you can have a child who had part of his gut taken out,
right,
or you can have a child who was just treated with antibiotics. So the varying levels of injuries are different, and we try those cases differently, and we work them up differently based on the damages for each individual plaintiff.
Interesting. And is there a separate action associated with saying this is human milk versus
and
they're selling cow's milk. I mean, that to me just sounds like fraud.
There's some evidence of fraud, but we're primarily arguing is what's called failure to warn. What that means is that this company was aware of the fact that there was an increased risk associated with cow's milk formula and NEC in premature infants. But what they failed to do is warn mothers and fathers when they were being given this formula in the NICU about that increased risk. So that's one of the arguments there. The next argument is going to be the idea that this product was designed improperly. It's what we call a design defect, meaning that this product was not designed for premature infants. So, and what I want to be absolutely clear on is infant formula is safe for a full-term baby. Cow's milk enzymes, full-term babies can digest that with no problem. Our specific argument is that this infant population of the 37 weeks or before are not equipped internally to digest it. So there's a design defect for that population of infants.
Where can people get more information about this?
So it's something as simple as Googling it, but really what this comes down to is being a smart consumer. You know, what we know from working in the mass torts world and working in this pharmaceutical kind of litigation world is that the government is not always going to tell you the truth. These companies, you cannot rely on them to give you information on it. And we can't rely on the media to tell the right story. That's why I'm glad I'm sitting here talking with you. So it is so important to be a smart consumer. It is so important to do your own research. So there's plenty of information out there that's going to summarize the necrotizing enterocolitis and the facts here. But what you need to do is every time you're using a new product, every time you're introducing a product into your child's life, do the research on it. Look it up.
Yeah, that's tough. That's a tough situation. I mean, because on some level, we're living in an era now where there's like vaccine denial and do your own research and on some level, like it shouldn't be that way. Right. I mean, and there's, if there's at one point, let's put it this way. If I was going to go do my own research about tobacco, 25, 30, well, let's say 40 years ago, it would probably lead me down the wrong path.
Yeah. And that's a fair point. But when I say you can't necessarily trust mainstream media to tell this story, I say that because if you look at the marketing practices of the infant formula industry, they are funneling millions of billions of dollars into marketing practices, just like we saw with tobacco.
Right.
So there is this balance of where do I find the right information and how do I get it? But taking the steps to do so are ultimately going to protect you in the long run if the information is available.
I just still can't get over how is there not? Do you guys ever recruit, let's say, like a state attorney general? Like, I don't know how many X number of millions of pounds of baby formula has been marketed to premature babies in New York State. Would you ever do lawyers like you go and present this stuff to the state AG and they start an action that, does an overall determination on whether this has happened or is there ever, because I know the state AGs were involved in the tobacco settlement. What dynamic, what possibilities exist there?
There's certainly possibilities. And this is especially one case where it is more possible than it is not, because you've got programs called the WIC programs, which is just women, infants, and children. And the WIC program has contracts with these major formula companies where they promise to buy X amount of formula. So ultimately, there is an argument that the attorney generals could pursue this litigation on their behalf. But when you're dealing with litigation involving state entities or attorney generals, it is always proves to be difficult because you're dealing with another layer, and that is the political scheme. Yeah. So is this attorney general ready to take on this massive corporation? And it's always a big push. I
imagine these cases also extend beyond the terms of any given attorney general.
Right.
Sara Papantonio, real pleasure to have you on, and thanks for the information, and appreciate it.
Thank you very much.